Afternoon, and welcome to the afternoon session of the Court of Appeals. Your panel today includes Judge Armstrong, Judge McGee, and I'm Judge Golden. Madam Clerk, do we have anything we need to address before we begin?
No, Your Honor.
You may call the next case.
Masterfit Medical Supply versus Samuel Bada, DBA Primecare, DBA New Primecare.
All right, we'll hear from the appellant.
Good afternoon, Your Honors. My name is Bada Anyanwu. I practice out of Madison County, and I represent Samuel Bada and Primecare Clinic, which is a defunct clinic at this point. I have asked for 5 minutes rebuttal in this case, and if you may ask.
Now, you granted the rebuttal time. You may proceed.
Yes, Your Honor. Thank you. Your Honor, this case is a simple arithmetic case. Unfortunately, the problem we have is the issue of deny. If there's no transcript of the proceeding, deny again and deny again and deny again. It may be clever lawyering to be exact. However, it gives a bad taste to the clients that we represent and the oath that we swore to uphold justice. Issues upon issues upon issues were discussed in the court. Yet, there's denial. A client was sanctioned for what? Because he was overseas, could not come back to the United States because of COVID restriction. His attorney has children that he cannot leave and avoid COVID infection, whose wife is ER doctor and who is running away from all this COVID, other than to be sanctioned that you were unable to do what? You were unable to produce the evidence we are asking, therefore you are going to be sanctioned. It makes no sense. That is unjust. Despite all effort made, accounting made. To the contrary, the evidence presents itself. It's as simple as ABC. You are alleging, the appellee is alleging that they were overpaid. There was an agreement inside the courtroom to have an accounting done where both parties participated in the accounting, and the accountant came with an affidavit as well, which is on the record, that Dr. Bada and Primecare overpaid Masterfit in such amount. Yet, the argument here is you failed to admit, therefore you are going to be sanctioned. It does not matter anything else that you did. Whether you ask for vacation of the order granted or otherwise, it is irrelevant. It is irrelevant. What is Dr. Bada seeking here? Should this court, the appellate court, look at the rules? Rule 702 Tennessee Rules of Civil Procedure specifically says what it says. Unfortunately, the opposing party is misreading it and telling this court that you must do your motion in writing. It does not say that whatsoever. Contemporaneous oral motion can be heard during trial. If you did not do it, what else do? You then go by writing. Also invoking Rule 36. again in error. I don't know what else to say to this court other than for this court to look at the two issues raised by the appellant and using the abuse of discretion standard. What happened here? There's a plethora of evidence to the fact that the invoices were overpaid. The invoices were paid and overpaid. More so, having to sugarcoat and clamp down a meritorious case on the grounds of technicality. Well, if you did not follow the rules as stated in our Tennessee Rules of Civil Procedure, you lose. But there's nowhere in the appellee's pleading or brief where they said that they were not overpaid. No, they were overpaid. Rather, what they are saying is, you did not follow this rule, you did not follow this rule, you did not follow this rule, therefore, you are locked out. I analogize it to going to Walmart or Sam's or any of these grocery stores or a supplier, buying items or goods and overpaying, and then coming back after seeing that there was an overpayment of the invoices. Oh, they're saying, no, you can't come in. We cannot give you a refund of the overpayment because we have closed our cash register. It does not make any modicum of sense. Where the court is to sanction Dr. Bada because he was out of state, he was out of the country, to be exact, he was in Ghana. And he could not come back because we know this quite well, there was restriction. Planes were not coming into the country. I cannot manufacture the evidence for the appellee. I had to wait for my client to come back in town to have the evidence presented to the appellee. And that evidence was fully presented to the appellee. And then when they found out that they are the ones owing now, they are now rigmaroling, trying to use technicality to circumvent $30-something thousand of overpayment. That would be a miscarriage of justice if this court of competent jurisdiction is to allow that to happen. That would be a miscarriage of justice. That would be unjust. It does not make sense. Yes, we can lawyer as much as we want. We can use the rules as much as we want. But common sense dictates here, which this court must understand that the records speaks for themselves. There's not much to discuss here. The record speaks for themselves. There's affidavit from the accountant both parties agreed to. But guess what? Your honors is denied, because there is no court reporter taking note of all those things. I will yield for now.
All right, thank you, sir. You'll have your rebuttal time. We'll hear from the appellee, please.
Good afternoon, Your Honors. I'm Brad Seger from Jackson, Tennessee. I do represent Masterfit Medical Supply. I think that the appellant is trying to assert some matters which have no basis in the record. His statements about his client being out of the country, there's no affidavits or anything else in the record to that effect. So I will just try to address what I feel like are the issues. And I will not try to read you my brief. It's short, but the few things I want to be sure the court understands is
Let me
that,
ask this, Mr. Siegel. According to the court's record, there was a sanctions issued for failure to comply with discovery. Was there anything referenced? I assume that there was a hearing on that, or
yes, sir, there was.
and was anything raised about the fact that an inability to comply or anything of that nature?
First of all, Your Honor, there's no transcript of that, and there was nothing raised that I recall whatsoever.
There's no pleading filed indicating any
No
of that?
pleading filed in the case saying that.
No affidavits?
No affidavit.
All right, sir. Go ahead.
All right. Now, the issue raised by Dr. Bada is, should he be allowed to withdraw the admissions? That's the sole issue he's raising in front of this court. Let's be real clear about that. Summary judgment was granted in September based upon admissions that were established 2 or 3 months or earlier in a court order. I filed a summary judgment motion addressing his personal liability. They have not appealed that. That's not an issue raised in their appeal. My summary judgment request basically said you're personally liable, which Judge Atkins found. And it also said the admissions, which are set forth in Judge Atkins' order, are the amounts. I didn't even have to address that at summary judgment because they were already conclusively established. Now,
Judge Atkins' order actually says that counsel for the defendant conceded that there is no dispute that defendant Samuel Bada operated said clinic as a sole proprietorship.
correct. So if he operated as a sole proprietorship and the amounts of the invoices are already conclusively admitted, that is the basis for the summary judgment. Now, the appellate says that they should have been allowed to withdraw those admissions. And there is a procedure set forth in the code that says how you do that. And it says you file a motion under Rule 36.02 to request to withdraw. They've never done that whatsoever. Their allegation that there was a overpayment, my belief, is what would be called a compulsory counterclaim. They never filed a counterclaim whatsoever. So summary judgment gets granted based upon the undisputed personal liability and the conclusive admissions. And that's where we're at. Then, and only then, does the appellate, after summary judgment is already established, after it's already ordered, he comes in and files a request to amend to assert a counterclaim. Again, you can't amend after summary judgment is already granted. And he also alleges an overpayment, which is his counterclaim. But again, all this is post summary judgment being granted. The rules do not allow that. There's a simple procedure. You file your motion timely. There's a simple procedure for filing counterclaim. You file it timely. None of that was done. And so it's just beyond me how we get to this issue, the sole issue they've said they should be allowed to present, which is should they be allowed to withdraw admissions or amend the admissions concerning the validity of the invoices. They didn't ask. They simply didn't ask. So how can the trial judge know this court, at least your predecessors on this court, in the case of Wallum versus Marshall, Judge Hires said, hey, we judges aren't clairvoyant. The opposing side is not clairvoyant. We don't know what you want unless you put it in a motion. That hasn't been done. It is too late to do that. And so I think the summary judgment was proper. And additionally, and I'm quoting from Judge Stafford, in his Rivergate Apartments opinion 338 Southwest 3rd 882, says that it's within the discretion of the trial court, and it's an abuse of discretion standard to substitute its judgment for the trial court in overruling something the trial court's done. So this is an abuse. My belief, my opinion is this is an abuse of discretion standard that you have to apply. It's not a regular summary judgment de novo standard, but an abuse of discretion standard about whether he should have allowed them to withdraw the admissions, which again, it's beyond me how they can do that when they didn't even make that request according with the rules. So I believe summary judgment was granted properly, and
So there's no motion in the record requesting that. Is that what you're saying?
Your Honor, there is a motion post summary judgment
Oh,
where he has to file a counterclaim, and he also post summary judgment. And when I say post, I'm talking anywhere from, I don't remember the exact days, but it was 20, 30, 40 days after. I think they recognized what they should have done pre-summary judgment and attempted to do it post-summary judgment. And that was simply flat denied by the judge, and Judge Adkins. And that is an abuse of discretion standard, I believe, which this court should not overrule. I'll be happy to try to answer any questions you may have, but that's simply our position.
Any questions?
No.
All right, thank you. Yes, yes, sir.
Sorry.
You have 5 minutes.
Going back again, I'm of the opinion that co-counsel here is mischaracterizing what happened during the summary judgment disposition. There was evidence on record. I do not have to. The record there is there. It speaks for itself. The accounting was presented, is on record. There's an affidavit on record during summary judgment proceeding. Did the appellee argue on an overpayment that was made? The answer is no. Did the appellee argue on anything else other than, Your Honor, you have stated that these invoices are admitted, therefore the case should be closed. Nothing else. There was no counter argument that these invoices, yes, there's an admission. Dr. Bada operated 3 clinics, 1 in Jackson, 1 in Hardeman County, and 2 in Hardeman County. And did he at any time ordered materials from Masterfit? The answer is yes. There's no question about that. The issue here is all the invoices that were presented, were these invoices paid? Were these invoices paid? That is what they have not answered. Were they overpaid? They haven't answered that either. Until they can come up and refute the accounting that was done by both parties in this case. Mr. John, who is the owner of Masterfit, and the accountant coming to address all the issues presented in this case and brought the fact that Dr. Bada has overpaid on the invoices that were present. That's the bone of contention here, not whether Dr. Bada ordered the medicaments. That's not the issue. The issue is, has Dr. Bada fulfilled his legal obligation to the invoices to the point of overpayment? The answer is yes, and appellee is not trying to refute that there was no overpayment. What the appellee is saying is again and again and again, if there's no transcript, deny, deny, deny. What appellee is saying here again is what? We should not even decide this case on merit. There's no, we should not even disturb it. Let the dog, let the lying dog sit, let it sit there. We should not even look at it again. But that would be a miscarriage of justice. Appellee has not said that there will be prejudice here if this case is heard on the merit. Tennessee is one of those states. Since I started practicing in this state, it's one of those states that requires cases to be heard on their what? Their merit, and not on just brushing it aside on mere technicality, which they are trying to do here. If this is allowed to happen, it then means that justice in this case has been eroded. That is all that is to it. It's all about who owes who. Did I owe you? Did you owe me? If you owe me, you pay me. If I owe you, I pay you. In this case, Bada and Primecare Clinic overpaid. If they are now saying that they should not refund the money, that is a different matter. But were they overpaid? Yes, of course, they were overpaid. The evidence is there on record. There's an accounting done by an expert on record, and they did not refute it during the summary judgment hearing, and that was part of the evidence presented during summary judgment hearing. And then the judge just ordered granting the summary judgment based on the request for admission, which was not answered answered early due to COVID restrictions and inability for the client to come from overseas.
Thank you. Thank you, gentlemen. We'll take your matter under advisement and get you a written opinion as soon as possible. Thank you for your argument.
Thank you, sir.
This
Thank you,
honorable
Your Honor.
court stands adjourned.
It's okay to leave the screen?
Yes,
Yes,
please.
you may leave the meeting.
Thank you.
I'm going to move us into the room. Kevin,
Yes, sorry about that.
Thank
Breakout room is open now. There you go. All right.